pledge allegiance
to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all.
Good evening, everybody. Should I get a motion to open up the August 8th town board meeting?
So moved.
Second. All in favor?
Aye.
I'd also like to have a moment of silence. Councilman Florio's dad passed away this week. Thank you. All right, first item on the agenda is a public hearing, introductory law number 9 of 2024, amending chapter 93 entitled Water. The purpose of the law is to amend chapter 93 Water of the Town of Goshen Code. Do I have a motion to open the public hearing for introductory law number 9?
So moved.
Second, all in favor?
Aye.
Any comments from the board, or would you like to have Bill explain it to us?
I have a couple comments, but let Bill go.
Sure. Yeah.
Hi, I'm Bill Ryan, and I'm special counsel to the town for water and sewer matters. And what we did with the local law that's in front of you now is really codify what we accomplished last spring with respect to the consolidation. And my attempt here was to bring you into the 21st century. And the most important points here deal with the type of equipment and infrastructure that must be installed when you are, or when an owner or developer is installing water mains and laterals, and regulations for private fire protection and temporary service. The most critical part is towards the end of the law. I believe it's section 29, where we have the allocation of costs and the operation and maintenance expenses. The language contained in there, gentlemen, is no different than what we had developed through the consolidation of the water district, how the rates are determined. And the other point that needs to be made is, as you know, each November you go through a budget process here, and that's no different. Over the course of the autumn coming up, you're going to be in a position of determining what the rates are going to be for water for 2025, and that'll be part of the public hearing. And at that time, your citizens will have the opportunity to comment, if they so elect, on the rates. That's it, really, in a nutshell. I'll answer any questions that you may have. Yes, sir.
George. I was sharing with a couple of board members. I was cleaning out files this morning, and I've got this letter from the Office of the State Controller, and it talks about town and county special districts and town improvements, and certain things we have to communicate to them. Are you aware of that?
Yeah.
Okay, good. Fine.
Okay, George.
Okay, so first issue for me was, I have found over the years that having a developer's agreement with new types of water and sewer districts really help us, because it becomes more efficient as far as we're concerned. Sometimes we get some money to do other types of things. Is it possible to get a developer's agreement clause in here?
You can, but the better approach for that is, and I don't disagree with anything you said, the better approach may be for you to consider during the planning board process, when a developer comes and wants to install infrastructure, that you enter into an agreement with that company then as to what the obligations are that he has to undertake. I mean, when you're dealing with like a new development, let me speak in that type of generic situation, the developer should sign an escrow agreement, which would require him to put up a sum of money and or post a bond so that you can be assured, you meaning the town board and your planning board can be assured of the fact that the installation is going to take place according to the building plans that have been approved by your building department. And undoubtedly, development also entails a town designated engineer, if you have one, reviewing the plans and specifications for the installation of the infrastructure. And that escrow agreement will provide for the developer to pay the town designated engineer and also to pay for the cost of any special district work that I or any of your council may have to undertake to extend a water or sewer district. You certainly can add language in here about a developer's agreement, but I think the better approach is to tackle that up front at the planning board level.
Okay.
And I'd be happy to draft that because I've done it in the past for other municipalities, and it's quite easy. It spells out, like I said a moment ago, what the obligations are of the developer.
Well, my personal opinion is I would like to see a clause in there about the developer's agreement in there because it doesn't come easy. The developer never volunteers that type of stuff. But I know of 2 cases that I've been on this board where it actually worked out fine because we saved the developer from doing other types of things. One was a standpipe. So he didn't have to put in the standpipe, so he was willing to give us money towards improvements to the water, to district. So I guess when I was thinking about this, I said, you know, been on the board now for 16 or 17 years. For the first 8 or 9, I didn't even know there was such a thing as a developer's agreement. And then it was actually Rick Golden who brought that to our attention. And I think we've been pretty zealous with that, of getting developers' agreements, and it really has helped the taxpayer. So I would like to see it.
So what I'll do is, I can add language in there, it's no problem at all, that simply says that in addition to other, requirements for the town, the developer agrees to enter into a developer's agreement that will provide for, you know, the obligations of the developer in order to obtain a building permit, etc. I can, that's not a problem. I'll add
Okay.
that. Not tonight, though.
No.
I gotta go back to the well and tap the pen.
Right.
So we could adopt it based on,
That's right.
correct.
And then the language of the resolution allows me to do that, to make those changes.
Okay, so the second thing that I had was, I see you have a severability clause. Should there be a superseding provision in there as well?
Well, we are repealing what you have now, so why would you need the superseding clause?
Well, I'm going by council, and let's see where to go. The other thing we're doing tonight with solid waste, there's a severability clause. Essentially, what I've been told, and you're the attorney, I'm not, that most, if not all, local laws nowadays should have a severability clause in it.
Oh, I do have that.
Okay.
Section 6,
Oh, no, I'm sorry. You do have a severability. I'm talking about a superseding provision.
that this local law supersedes the prior local law?
Well, the language that I have severability clause reads, if any clause, sentence, paragraph, section, or part of this local law shall be adjudged by any court of competent, that's severability. Superseding is, to the extent that any state or local laws fail to provide specific authority for this local law, or the procedures necessary for its adoption, or otherwise appear to be in conflict with this local law, or the procedures followed for its adoption, then such laws, including but not limited to Article 16 of the New York State Town Law, are hereby superseded by this local law pursuant to New York Municipal Home Rule Law and the Common Law. In most local laws that we pass now, we put a superseding provision in, and I'm just wondering whether there should be one in this.
Well, I can add that.
You can add it? Okay. I see that you had, in the fire protection part, you had,
What section is that?
this is Article 5, fire protection. My question though is, in the fire protection area, there are going to be as-bills that will be provided, but what I was wondering whether or not there should be as-bills provided for the other parts, not just the fire protection, but as-bills for, the construction of all the water mains.
I have to get there. What's your question again, sir?
Article 5C says the applicant.
You're at section, okay, the applicant will furnish as-built drawings stamped by New York State licensed architect or engineer.
C is the applicant will furnish as-bills.
Yeah.
No, what I'm saying is, it's clearly in that part, as far as fire protection, what I'm saying is, I didn't see anywhere where as-bills were going to be provided for the water mains themselves.
Well,
Isn't that done in your planning process?
that would be taken up by your planning board.
Well, I guess what I'm saying then is, why would you put as-bills in for the fire protection and say they must be as-bills, and then not have as-bills put in the parts where they are providing what the water mains are, where the water mains are, where the hydrants are, where the hookups are? Isn't that part of as-bills?
I really think that language in Article 5 that you're referencing deals with the situation.
Making sure the architect is licensed and stamped.
Yeah, deals with the situation you described.
No, it's clear in my mind about the fire protection part. As-bills are going to be provided. All I'm saying is, I didn't see anywhere in this document where as-bills were going to be provided for the rest of the stuff. The water mains, the hydrants, the hookup parts.
And my answer to that is that is something that's done in the planning process with your planning board.
But isn't it in the next section? The hydrant section provides hydrants and drawings.
Where's that?
As-built.
Where's that, Joe?
The next section. Section be private hydrant. Detailed plans and drawings of any and all such installations shall be furnished to the approval of the town board. Any permit installing or built to shall be issued. So it's inspection of the as-built and drawings furnished to the town board for the fire hydrants and lines. I don't know if that's what you're asking, but
Well, I've said it a couple of times, so I'm not going to say it again. You're saying it's going to be provided by the planning board, so let's
well, it's
move.
part of the SEQA process.
Yeah, well, let's move on then. Next is Okay, the next thing is, I just want everybody to be aware of this, and that is on, yes, it's Article 5C. The pages aren't numbered, so it's hard. It says, the town reserves the right to require any sprinkler system installation or any hydrant system installation installed prior to the date of this local law to be brought up to the standards referred to at any time. So effectively then what's going to happen is potentially is anybody out there in the community that has a sprinkler system now will have to update it.
Can you,
It's section 24. Right? Yeah, section 24.
And I'm just wondering, I mean, it sounds like a great idea, don't get me wrong, but it sounds like it also might be a pretty big expense for folks that have already sprinkler systems in line.
well, it says the town reserves the right to require any sprinkler system installation or any hydrant system installation or prior to the date of this local law to be brought up to the standards referred to at any time. You know, the town is reserving that right. You don't necessarily have to do it.
But I can tell you the Board of Health requires it, because I just had to do it in my restaurant. Had to bring it up to speed. So we just spent like $15,000 putting in a new water system. So it is a requirement at the county level.
Okay, the next thing, which, Mary, correct me if I'm wrong here, we will now, with the public hearings that will be held every year, we'll have a ad in the paper notifying the people of what the rates are going to be, which hasn't been the case in the past.
Nope, it has been.
It has been, okay. I missed that then, okay, that's good. And last but not least, just a general question is, I assume you looked at 93 all the way through and culled out all of the different things that were important and incorporated them into this document.
That's my intent.
Right, okay. So I just, needless to say, I didn't read all of 93 and then all of the new thing, because that would have, I'd still be there. I'd still be reading it. But anyway, what I came back at is I just took some isolated things. 9310, 9334, and 9335 were all things that I think,
9310, what were the second and third?
9334,
35.
which talks about standpipes, and 9335 talks about long sprinklers being prohibited. So what I'm saying is those things, I think, as far as I can see, really should be incorporated into the new document, but I didn't see them.
Well, my approach here was this local law was based upon my review of Section 93 in your existing law, and my work with engineers over the last 20 or 30 years, and to provide you with the current document. If you want language in there from those three sections from your existing ordinance, I'll do that, but I think you're adequately covered for all those points.
Well, I mean, just as one example, I think I didn't read the whole, I didn't bring the whole read out, but long sprinklers are prohibited under 9335. They are not prohibited in the new.
Well, do you want lawn sprinklers prohibited?
Well, when we have water districts that are running out of water and we're having problems, I think it might be a legitimate reason, especially because it's in the law now.
But the law hadn't been amended in a number of years, as I recollect. If you want me to put language in there that carte blanche prohibits the use of lawn sprinklers, I'll put it in.
Oh, that's what I said, but
Do we
I'm
currently
one
have-
person.
Currently now, lawn sprinklers are not prohibited unless we're in a water drought, right?
Are prohibited. 90, the way I read 9335 is lawn sprinklers are prohibited.
I could hire a full-time code enforcement officer to go around the town and write tickets all day long.
Well, because there are so many.
Yeah, I didn't realize that. I thought it was only during the prohibition. I mean, only during the shortage.
Well, then maybe we don't want that.
Yeah, yeah. I mean, that's a real problem, I think. You're talking about the external sprinklers, the ones that you just hook up and.
No,
What are you talking about?
no, I'm talking about ones that are actually put
That's
in.
actually part of,
Yeah.
the part of the
It's
system.
drained in the winter and all that kind of stuff.
That's one, make sure.
I think
So we
we
don't,
I don't think there are too many of those.
No.
no, I thought you were talking about like just.
No, no.
hose
Yeah,
out
so
on the thing.
that's why I said that, I'm like,
No, I
you
wasn't
can't
thinking-
really prohibit that.
I wasn't thinking of that
Yeah,
at all.
yeah, okay, you're talking about the
Right.
ones that are part of the infrastructure.
Right.
Yeah, I agree with you, George.
But I think today
Yeah.
it's prohibited, also swimming pools, you're not allowed to use town water to fill swimming pools. So those, because it puts us in a,
Right.
that's why you'll see trucks in our
Right.
subdivisions filling,
Right.
water trucks filling pools. So I'd have to go back and look, but I think that sprinklers are prohibited in using our town water.
You're talking about any type of sprinkler?
Lawn sprinklers,
The ones that are in the ground?
lawn sprinklers.
Oh, sprinkler.
Yeah, so they.
I was specifically talking about the ones that I think
Yeah.
should be prohibited are the ones that are actually installed and have to be drained in the wintertime.
And turned on in April.
Right, exactly. The other ones, no, I mean, some people want to sprinkle their lawn, they want to go out with their
Yeah,
hose.
but during the drought, they.
Oh, yeah.
They're prohibited during the drought
Right.
period also, those are also
Right.
prohibited, along with the car washing and stuff like that.
Okay, so that's what I had.
Yeah.
Yeah, listen, I mean, I don't see it being a problem putting them back in, with add them.
Those three sections, 10, 34, and 35.
Please.
You can take up this in the committee, is that what you're saying? Take up this.
He's gonna add them to it.
Yeah. Okay, good, yeah.
That's it.
Anything else?
Yeah, thank you.
Yeah,
Doug?
I've got a, you know, we've been told by the comptroller's office, we're not allowed to use general taxpayer funds in a water or sewer district. For example, Arcadia Hills, the tank sprung a leak about 5 years ago. It was $500,000 to put a new tank in. We could not use taxpayer money. What the money we used was money from the Arcadia Hills district.
Right.
Okay. And so I'm even looking at this. I don't know what it's costing us to do this, you know, but is this money, are we allowed to spend this taxpayer money? Because we're borrowing taxpayer money to do this. I think it's about $70,000 we've spent so far.
Not on me.
No. No, this is,
No, I
This
just,
was ARPA money that we set aside for the consolidation.
of the districts.
what now?
The ARPA money that we set
No.
aside.
This was money, according to Christine, because I went up this morning, and we pump water wells out in, early on, looking for water. Well, that was $45,000 or whatever, and then this is writing this or whatever. I don't know, I'm telling you something I don't know the answer to, but.
I need clarification from Christine, because I don't recall us pumping
No,
any
this
wells.
is part of the water sewer consolidation.
That's,
part.
No, this is producing,
No, it has to do with Arcadia, Hamiltonian. those
The existing-
no, I'm not
consolidation.
talking about that, I'm
No.
talking about
But this
this.
law is based on that, it's part of his work,
well, yeah, but
consolidation.
in the capital costs, I think what Doug is referring to, it says those annual fixed costs which must be paid by the town to reduce indebtedness, bondedness, or otherwise, which include but are not limited to land acquisitions, required reserves for repairs, replacement, or improvement to the infrastructure of the system, and any other cost which is fixed, recurring, and which does not include operational maintenance expenses. So they're talking about capital costs being paid by the town, so I'm
Relative to
not
the
too clear
production,
on this.
relative, are we talking about the cost associated with producing this law?
No, this is part of the law, it says capital cost, which is the cost to build any system.
I don't
And
think we're
pay
talking.
any bonds. So
Yeah,
that-
no, I agree with that,
I'm-
but I don't think we're talking about building anything right now, we're just talking about changing our code, not a law, to bring it up to date.
No, I understand that, but this does say capital costs of any land acquisitions or whatever we go in the future. If you look at the capital cost thing, and it says it's being paid by the town.
Well, the
And
town
not
gets
by-
the money,
well-
the town gets the money from your district.
From the developer.
Yeah, the town pays the bill, but they charge a capital cost.
I understand that, but if there's no district established, does that allow us to build an infrastructure for water and then create a district,
No, you have to create the district first.
right?
And then you have to create the district first, and if the town borrows
Right.
money to pay for the infrastructure, then it's a charge back to the
To the
district.
district, but
Yeah.
you have to have I agree with you, I know that. You have to have the district first and the buy-in of all the people that are in this district, but if you don't have any funds, the town cannot fund the capital costs with taxpayer money and then bill the district recipients for the amount that they have charged, okay? In a regular special district, we have funds established already. And we either charge those funds and then we tax them or however we collect from that special district, which now will be the special district for all water districts that are established. I'm looking at capital costs where they may want to build infrastructure going forward.
Without a
And
district.
creating a district, right, that's exactly right, without an established district. Because the district usually builds the infrastructure and dedicates to the town. There are no taxpayer funds that are included in that. In this thing, and I may be reading it wrong, that's what I'm saying. In this thing, it says capital costs, those annual fixed, and that's for, and it talks about land acquisition. So, has to be paid by the town, and it looks like we should get reimbursed from the district. That's not usually how it works. So, I could be misunderstanding this.
Have some clarification possibly?
You can clarify.
Normally, if you're going to be building a thing and you want that to be its own water district, and you
Right.
have to spend money, you have to have an engineer, you have to have a Department of Health approval, da-da-da-da. That
Who
will
has
be,
to have that?
and anybody, anytime you're
district-
building something,
The
the
district has
district
to
will have
provide
to.
that, not the town taxpayers.
Well,
That's,
No, no, but
understand
what-
the line I'm drawing here.
Or, what I'm saying is
Yeah.
that, in that case,
Yeah.
the district, which is part of the town, on behalf of the district, gets a low or a long-term loan.
Right.
And your annual charge is what goes to the people that are part of that district to pay back as part of the budget.
I
So
understand.
it's,
That's right.
Let me
That's how
say
it
how
works.
it is today
I-
and has been passed, okay?
okay.
Like Rigger Brothers, okay, they want to build about 100 homes. They buy the land, they do the pump down test, they do everything, they interface with the Department of Health and this one, that one. Okay, not one penny of taxpayer money goes into creating that district.
no, correct.
Building it,
If it's
and then turn it
developers.
over to it.
That's
Right.
what we're talking about.
If it's a
That's right. That's what
developer's
we're talking.
process, the developer pays to develop, and the district is created before anything gets developed.
I understand that.
And you have an agreement with the developer, as we already talked.
It says the annual cost, fixed cost, which must be paid by the town to reduce the indebtedness
And
paid by
then,
the town. But if we don't have a district established and we're building or we're developing a district, we don't develop, what it says here is there a capital cost. It looks to me, I want to make sure that I understand, to develop a district. Now,
no,
yes,
you're not paying, if the developer pays, and if a group of people come to you, can I just?
yeah, no, go ahead, I'm
speak? All
listening.
right.
I'm just listening.
If a group of people come and petition you under Article 12 of the town law that says, we want to put public water in this subdivision.
Right.
Okay? And then the map plan and report is prepared by the competent engineer.
Right.
and it's gonna cost $700,000 to do it.
Right.
The district's formed, then the town goes out and bonds it.
Right.
And then the capital charge associated with that $700,000 infrastructure creation or construction is paid for by the 100 owners of that development.
Right. I agree with you, that's how it works, that's how it always worked. I just want to make sure that what we're looking at is the town decides, you know what, I think we need a water district in this particular area because there are a lot of customers. So let's build the infrastructure, create the water district, and charge all these people what the town has paid to create this water district, rather than get the water district created and say, okay, you need to provide us with funding for escrow or whatever, in order to build this. What I'm telling you is I don't want the cart before the horse.
No, and you're not.
Okay.
And the situation you
Okay.
described is under Article 12A of the town law, where the town board on its own initiative can
Right.
create a water district. But that initiative that you, when you attempt to create a water district on behalf of some of your constituents, is subject to either, one, a permissive referendum under Article 12A,
Right.
or a mandatory referendum under Article 7 of the town law. So in that way, the town's not paying for this. The residents of the water district to be created pay for it, subject to either the permissive or mandatory referendum. So to answer your question, the
Right.
town is not paying.
All right, I'm fine.
Comfortable with that? You gotta be comfortable with it.
I'm not really comfortable with it yet, not with the language I see here, it's just, but I know we can fight this thing, but what I want to really do is not get into any kind of contest.
Well, I mean, Bill, how can you,
I know, it's clear.
how can you define the capital cost?
The capital cost, it says if a district is developed,
Well,
then when you start it and say, if there's a district developed, blah, 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 and the rest of it, that makes sense. This one doesn't say anything about.
Is there any way to accommodate what he's looking for in the definition? of
Yeah, it's
capital
simple.
cost?
I think the language is simple.
Yeah,
And-
simple.
And
Go ahead.
the language that I've drafted covers you and adequately covers the town. And it's just,
There's nothing gray in that, where somebody
No.
can say the town says, the town code says the town has to pay for this. We want the district and the town has to pay for it.
Correct.
That's what I think the councilman is concerned about.
Absolutely.
So if there's any way to redefine this so that we could accommodate, making sure.
It says nothing about someone forming an independent district, and then the town taking it over. What it looks to me
it doesn't
here is-
have to.
Well, to me it does.
Well,
I mean, if you put in here, I don't think it's a big deal. That if there's an established district, or with an established district, you can finish the whole thing. Those annual fixed costs, blah, 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 blah. But it says nothing about a district right now. It just
I mean,
says.
If there's a statement that can be put in as something similar to, that any of the fixed costs associated with this capital project, it cannot be bared by the town of Goshen, but rather the developer or the
Well,
residents, or
yeah, I
something
mean,
that they can.
you can add 2 or 3 words, and then I'm
That's what we
really
need.
comfortable with that.
That's what we need, because truly, the comptroller's office does not want us to use town taxpayer money to create a district and all this other
Well,
stuff.
that-
And I'm not
Yeah,
sure what
that-
the resistance could be. Why would you resist just putting that in? If it's double coverage, what would be the problem with putting it in?
well, there is no resistance.
Okay, then put it in, as far as I'm concerned.
I mean, is there a legal issue?
Yeah, that's what I mean, that's why I'm asking.
So then, simply, we're just gonna redefine it to say that the town, there's no cost associated with this development,
As
and the
long as
town
it's
will
an
bear.
established district.
Say that again? Unless there's an establishment.
Establish it, however you want to put it in there. I just want to make sure.
No cost associated with establishing this district will be bared by the town.
That's fine.
That's
Well, that's
However you
all,
wanna
okay,
put it.
that's fine. It's all under, it's all under Articles 12
12,
and
yes,
12A of the
understood.
town law.
That's good.
That's adequately protects you statutorily,
Thank you.
but I'll put it in here nonetheless.
Thank you.
You're welcome.
Is there anything else? I don't have anything else.
That's good.
Good? All right,
That just covers.
at this time, I'm gonna open up the meeting for public comment. Sue?
No.
Okay,
Sue Cleary.
my name is Susan Cleaver. I live in Goshen. From what I read on this, it says that you're repealing chapter 93. Your advertisement said that you were gonna amend it, which is a conflict in itself. And I started to do like George did. I started comparing the two, and I went through the first 2 pages and I said, I'm not gonna bother. And the reason I said I'm not gonna bother is your law says that you can't repeal it. So I'm gonna give this to George, because I don't know how you guys managed to miss this. But it says that you can amend the law that is in place, but you cannot repeal the entire law. So I would suggest whoever wrote this law, go back to the drawing board. I'm not sure exactly who it was, because I don't think it's legal in the first place. And then redo it, put your amendments in, and have another public hearing. Because I couldn't make sense of it. I really couldn't. I'm with George. I read this thing, and it looked good to me, the old law. I don't really understand why we're changing it. It was very specific about the way things are built and shut-off valves and everything else. Why we want to do away with all that, I have no idea. So, anyway, that's all I'm going to say. I hope that the board will get copies of this, and that you will have another public hearing.
Got it? No, you want to take a look at what Sue just gave us and what you saw?
Greetings, Priscilla Grossbeck. I too am questioning your reasoning at this point to change the introductory local law 9 is to repeal chapter 93 in its entirety. Why are you doing it at this point? To repeal is to nullify. And to amend is to upgrade, it's to improve, to make minor changes in order to make it fairer and more accurate and more up to date. So why aren't you amending chapter 93 instead of repealing? I don't understand why you're doing that, and why you're doing it happens to be at this specific time. Is there like a state law that says you have to do it like in 2024, or can you do it in 2025? Like Sue said, your own code even says you cannot repeal chapter 93. It's right in your code book. I've read it, she's read it, and I believe this hearing has been misrepresented. Your publication in the Indy says you're amending the chapter, but yet the black and white print says you're repealing. Two different things. You can't make an apple pie with oranges. I think we need a do-over for the misrepresentation. Or was this an intentional misrepresentation to the public? There might be people who are looking to see what parts you're amending, and yet you have repealing. Repealing is to nullify the whole thing, which your code book says you can't do anyway. So I think you need to go back to the drawing board, start all over again, and have another public hearing. I'm sorry.
Bill, would you like to respond to that?
Before I respond, the first paragraph of section 1.4 says, the repeal of local laws and ordinances provided for in section 1-3 of this local law shall not affect the following classes of local laws, ordinances, resolutions, rights, and obligations, which are hereby expressly saved from repeal. I need to read section 1.3, and I can't read this in a vacuum.
Okay,
Yeah.
so then it's only fair that we hold a public hearing open and, we'll get responses to some of their questions. I think they're legitimate. Okay? Jim?
Good evening, Chris Haley, Town of Goshen. Councilman Cantorino, your brilliance is dizzying. I appreciate the attention to detail, Councilman Lyons as well. Great questions. I also thought this was an amendment. I didn't get an appeal, I'm just getting that tonight, so that's got me on my heels. I did notice in Article 5, we talked about paragraph, or Section 24, sub A, sub C, and it says, the town reserves the right about the sprinklers. The town reserves the right. That ain't right. Look, it's either yes or no. To have a business out there that's got a sprinkler system and constantly hanging over their head that if I get on the wrong side of somebody, they're gonna come in and gig me for it, that's a hastily written law. That's bad. On the other hand, we're talking about.
I'm sorry, where was that?
So it's Article 5,
Let's see.
That's,
What am I talking about?
Part 24.
Okay, I'm looking at S5, sorry.
Yeah.
And Councilman Lyons, you were talking about, yes, the sprinklers, and it says the town reserves the right, which to me is, there's a lot of room for abuse there. Should somebody get on the wrong side of somebody else, and I completely agree with you that can be very, very expensive for some of our businesses to have to update a system that is fully functioning. It functioned yesterday, it will function tomorrow. Again, hastily written, and that's just kind of a catch-all. I just really don't like it. I think that needs to be looked at a little bit better. Going back to Councilman Cantorino's points.
If I could just say
Sure.
something real quick, so I'm sorry. So I understand what you're saying, but I can tell you that the Board of Health of Orange County is the one that actually monitors this, as well as the town, but the Board of Health will require you to do it. They've required me to do it.
But, and you're talking restaurants,
Yes.
eateries.
Mhm.
Well, there are other businesses with sprinkler
Yeah,
systems that
understood, but
do not
understood.
fall under the BOE, so, the Board of Health rather. It also, again, I really did think that this was an amendment, not a complete revocation of this section. I will agree with the previous speakers that I think we need to go back to square one and let's get this thing straight. And perfect politics, it really feels like you came up with a solution to a problem that didn't exist. It's a lot of something for nothing. What we had was completely working, and if it's not, then let's amend. But throwing out the other stuff and just replacing it, we'd really like a little bit more time to look at it. Thank you very much.
Anybody else? Neil?
Thank you. Neil Halloran, Town of Goshen. I have more questions than anything will come. On the first thing, where we talk about projects possibly in adjacent municipalities, I'm concerned with why we're doing that. I think we know right now that there's a town of Chester who's looking for water for one of their developments. So right away, I think we're going to see an application from there if we have it. The other thing I'm trying to have with out of community or out of Goshen things is that I think that right now, if you have a water bill that has not been paid, you can add that to their tax bill. I don't think you can add that to a tax bill in the town of Chester or the town of Warwick or anything else. I think that we can get stuck with, or the water districts can get stuck with the great deal of money owed to them, and not an easy way to go after that. I'm not sure of that, but that's a question I have.
In this update?
In this update, it says that you can have projects hook up to the water district within any adjoining municipality. And I'm just using Chester because it's right there. So if somebody in Chester wanted to hook up to here and you had them hook up, then if they don't pay their bill for their townhouse or their entire project, whatever it is, then I think you have no easy resource to just say, I'll put it on their taxes and get it collected by the taxes. And then what really happens there is that if they don't pay it on taxes, we get it paid for by the county. I think the water district can hang for that for a while.
No, listen, I totally agree with that, and I don't think there would ever be a situation if we were even looking at connecting to Chester where we would connect to Hacienda or something like that. It would be to a Chester district in the town of Chester be responsible.
And I know that's the way the village of Goshen did it when we were looking at.
So I don't think we would ever have an out-of-district individual user, if we're not even talking about that.
Yeah, well, I'm not talking about it now, but the law seems to be saying, yes, you can do that, and in fact, I think the law says that an applicant in another municipality can apply for that.
So we need to change that, because we would never approve that.
I would like to see it change. That just makes me.
When it first came up, I said I have no problem with an emergency basis. because I know sometimes if a town runs out of water on an emergency basis, you cooperate with adjacent
Another municipality.
municipalities.
Yeah, right,
But
exactly.
only on an emergency basis and not on a, and I specifically said it shouldn't be a profit center. Water or sewer should not be a profit center.
I think we have that for Ham Park, I think, as an emergency connection to the village of Goshen also.
Right, right.
In the reference standards, my only concern here is that there's no identification as to what version of the reference standards. And I realize sometimes we, certainly with the Department of Health or with some of these other regulatory agencies, we have no choice. We're gonna have to use whatever their most current is. But I think some of these others are not regulatory. I know in the building code, we use the ICC or International Code Council, but we always look at that and say, not we personally, but we, the state, looks at that and says, all right, we're going to accept these parts and not those parts. I would caution you that you may be automatically buying into changes that you may not want in the future without having the ability to say which version you're going to use or whatever. In these definitions, under commercial service, industrial service, the word predominantly is used a lot. That just seems like a perfect thing for lawyers to make a fortune on. And I'd love to see predominantly, not just gentlemen, he's not going to, but I think that it should be defined somewhat what predominantly means. And I'm not going to pretend I have any idea how you should define it, but it just makes me nervous having something that's so gray in the code. Okay, down here, other person, and I think under permit, you have other person defined, and I'm assuming that residents and citizens of the community are allowed to go for a permit. You have plumbers, contractors, everything else, but.
You have the section that you're talking, so we can just.
I'm sorry, I'm under definitions. Okay, under section 8, nope, I'm sorry, under section 9. So I'm just under definitions there, under permit.
Yep, I got you, go ahead.
Okay. Under residential service, domestic only, domestic nature only. Again, the residential is not necessarily defined, and my concern there is that residential under the building code includes townhouses, condos, hotels, motels, anything that like that. So I don't know whether you intend to that to be considered residential or is that commercial. And again, I just think maybe you need to find that a little bit more clearly. And I think we kind of had this question under the definition of town. So we kind of had the question of from Phil as to whether town includes the entire town or whether the town, and I think the young lady over there said before, sometimes the town board acts on behalf of the water district. And I think that's really what you're doing under this, and maybe that should be defined there, the town acting for the water district or whatever. And then in here, you also, under town board, or its authorized agents or representatives. That kind of concerns me that it seems to be telling you can go ahead and deputize people to make your own decisions that's really your responsibility. I think the responsibility always falls back on you, and you can't.
I think they're looking at planning board and zoning board, not individuals.
Okay, yeah.
So you wanted to define it as instead of agent, planning board, or any
Maybe, I think you have to figure out.
any authorized agency of the board.
I was thinking more in terms, you might say, all right, we're gonna let the town engineer make those decisions. I think the decisions really come back to you, and certainly the town engineer can certainly give you advice and you can follow it every time. But I think it ultimately comes back to you anytime. Okay, under the definition
So
of
essentially just eliminate authorized agent and representative. And
maybe,
make it
yeah,
come
whatever you're comfortable with. Okay, under the definition.
I'm not saying I'm doing that, I'm just
Okay.
I'm asking if that clarification, what he's looking for.
Okay, under the definition of undeveloped, the inability, it sounds like undeveloped means it can never be developed. Maybe, I don't know whether we want to say, make that determination that some land is never going to be able to be developed, or whether it's just currently vacant. And I'm not sure what the reason for that undeveloped in there is. Certainly property at this point in time can be undeveloped, and then it could still be in the district, then maybe can be developed in the future, just hasn't had any action on it yet. under section 11, new services, then there's a thing in there on the very top, in accordance with section 24. Section 24 refers back to private hydrants. Private hydrants are not the hydrants that we see along the roads. Private hydrants, I'm not sure we can, excuse me, we have any in the town. Private hydrants are those that are put in on property sometimes, I'm sorry, we do. We have them up at Legoland. There are numerous private hydrants up at Legoland that are not ours, nor are they our responsibility. But in this case, we're talking about hydrants that are on municipal systems. And we're referring it to section 24, which by definition, somebody had it before, where it's about private hydrants. I think that needs to be cleared up a little bit. Under C right there, no agreement check will be entered into by the town. I'm not sure whether you want to be no agreement or no application should be, unless they have their fees paid up. Why even accept the application if you're not, and go through the process when they say right now we can't approve you. No, we're not going to waste our time looking at it, maybe. Okay, under section 12, installation and requirements, any repairs, additions, or alterations. I think the question there is removal also. I think you may want to, if you have a house and you're going to remove that, I think that also needs to be included in that. I don't think you want anybody taking out a house in Ham Park or whatever and removing the water lines back to the blood without you knowing about it ahead of time. I think somebody in town should know about it ahead of time. Okay, again, on the B there, a separate service line shall be required for each dwelling or any other building. You don't define dwelling in here. A dwelling under the building code includes anything that whereby you can cook, sleep, and eat there and wash there. So that I can have townhouses like that, I can have condos like that, I can have hotels like that, where I actually have a long stay or short-term stay hotel, where I have cooking facilities in there. This seems to be requiring that each one of those units within that hotel
Correct, directly.
must have their own meter. I'm okay with that.
How about each single-family dwelling?
Or a two-family dwelling. If you want two-family, I don't know what you want. But I think we need to figure out what we mean by dwelling and figure out how much we want that. And who's gonna end up paying for that. Because ultimately the water meters or the water bill's gonna go to somebody. It's gonna go to whoever has the bill and whoever has the meter. So if you're gonna do it for every dwelling units, excuse me. Like we have that one proposal in front of us where there's a bunch of either, I guess townhouses or, no, not townhouses, condos or apartments. And I don't know whether you're gonna have each apartment do that or what. Okay, okay, so just I think the dwelling needs to be defined somehow. Okay, on the next section, 13, it says you need 2 sets of stamp plans. I think you're gonna need more than that. If Tam is gonna go out, and I'm sorry, I don't mean to, but Tam does a lot of work, so I just no, I'm not. But if Tam's gonna go out and do work, they're gonna want a signed set of plans. The town's gonna want at least one signed set of plans for in the office here, and it's gonna be more than that. So you're gonna need more than 2 signed sets of plans. Maybe it doesn't matter, but you're gonna need that by the time it goes for construction. Under B, they have these that has to be approved by the Department of Health and that. The other question I have is whether or not the DEC has to be included in all that. I'm not sure that the DEC has the requirement about wells, or if that sticks with the DOH. I don't know. Then it says that it should be reviewed by standards under subsection A above. And I didn't see a whole bunch of standards in subsection A above. It seemed to be just very vague. I think you need more fleshing it out to know what standards are going to be required there.
I know.
And there was a question as to as-built before. Certainly as-built are not a requirement of the planning board. The planning board does propose. The as-built is when it's constructed already. So the planning board is not involved with the as-built. I mean, you need to get that. And in fact, we know that from heritage estates. If you recall, Heritage Estates
Yeah.
built their water lines outside of their property, under somebody else's property, by a significant amount. I'm saying a quarter mile of pipe went the wrong way. So it needs to be done as an as-built. I would suggest that there's a part in here somewhere, and it's probably right here under D, that they have a survey that says you have to have a survey at the end. I think you have to have a survey at the beginning before you make the screw-ups. There's no reason why a survey shouldn't be done to lay out the lines, just so that where they belong. I know that we had an issue in Ham Park where we had a sewer line running underneath somebody's house from a long time ago. It was a wonderful thing. Okay, and then in D it says it must be turned over to the town. In the past, we've always had that it must be offered to us. I'm not sure whether you want to take every one over or whether you're going to still want it, and it must be offered to you, and it's at your option whether you take it over or not. Again, it's up to you how you want to do that. On that same section 13, under D at the very end, in addition, proof must be shown that the valve box locations at the bed. And it's proof by who? I would suggest that we have, again, it's almost a survey or something like that. I don't want some of these contractors who come in to say they did it themselves and I swear it's where it belongs. Okay, so maybe you need this proof by a third party or whatever. Okay, and on 14, a performance bond or certified check. And I'm kind of asking here, are we going to leave that open to them or to us? Who's going to make that decision, and do we want to leave that decision in there?
Well, we already know that we don't take performance bonds.
Well, then, my suggestion is to be that out of law. I'm okay with that.
Yes.
Well, needs to be a.
But I think every one of our laws does either or, and then we tell the applicant we only take the cash.
Yeah, but I mean, we're writing a new law now, so, or we're modifying it, whatever we're doing, but anyhow, we're making changes, and if we don't want it, we don't want performance bonds, and let's just get out of that. And I agree, we've gotten stuck with performance bonds because it's like insurance. If they don't pay the bill, then the bond's all over there.
Yeah, well,
I think we just made it.
a lot of the things we're stuck on because they weren't followed.
I agree.
There's a thing down here about testing under number 15. And again, I think it has to be by a third party. I don't know who you're going to have do testing. And the other thing, and this always blows me, number 16, that the work shall be guaranteed for 1 year. We have better guarantees on our houses than 1 year. This is significant. I don't know why we always shut it down at 1 year. And probably the answer is going to be it's reasonable and customary. Well, I think it's unreasonable and customary maybe, but just to have people who are constructing these or inspecting these or whatever and say, all right, you have to guarantee it's going to be good for 1 year, is pretty strange. We have had issues with, when Heritage Estates was being built, we had compaction around some of the manholes and some of the storm drains and all that. And before the thing was even finished, possibly 6 months, 9 months later, we had sinking around them of 1 foot or more. So it doesn't take much more than a year. If you get by for a year, you might be okay, but you're not going to get. These things happen, and we had that problem after years. We've had it in Arcadia Hills and whatever. We've gone around and had to fix all around these places. I don't expect a 24-year or 20-year bond, but I think more than 1 year is certainly suggested or good. The other thing we always do is when we have these bonds, we always go, all right, Sean always does this review. This is the cost of all the infrastructure. And then we come down to the end and we have to have 10% for the bond, for a maintenance bond. My concern there is that oftentimes what we use is it's 10% of the cost if done privately. Well, if we take it over and we have to do it, we don't get to do it at those rates. We have to do it at prevailing wage rates. So that bond should be based on prevailing wage and our real cost. not the rate of what a contractor can do it.
But that's what Sean does. He bases it on prevailing wage.
Not, he didn't always. I don't know if he's doing it now, Joe.
Yeah.
I think he
Okay,
does.
I hope so.
Yeah, I think.
The bond that we have in Heritage right now for the
Yeah.
green sand system is based on prevailing wage.
Okay, the bond or the bond
Cash bond.
for building it, okay.
Yeah.
And certainly at the other end, when we get the maintenance bond on it, I hope it stays in prevailing wage.
For where? For
I'm
where?
assuming you're gonna build that, and it's gonna be a building, a bond for building it. And then you're gonna have a bond for 1 year, I guess, for guarantee? I don't know.
I'm sorry, what are we talking about? I'm talking about the green sand system that already, the building already exists there, the wells are already done, but now we have to introduce the green sand system to the wells.
Right.
That money that was put up for that was bonded by Mumford at the prevailing wage that Sean developed.
Okay, all right.
My understanding, that's what
And
it is.
you could be right, I've been at it for 2 years almost. Okay, thank you.
But you're just talking about in general.
In general, yeah,
You're
yeah.
talking about a maintenance bond.
Sure, I mean, when we had,
In general, I mean, that's a sand filter.
Well,
We're talking about roads or whatever.
Sure, Golden Ridge or
Yeah,
Maplewood when you have
right,
Maplewood,
right.
or Regan when you come in.
Right.
I think all
I
those,
understand that.
everything there has to be a prevailing wage.
Right.
I think we're looking at, Mary, didn't we get a complaint today about a sinkhole in Heritage?
Yes.
So, that's 4 years later.
Yeah, I agree. I was very concerned about that project when we were building it.
And we only use 5 years.
Well,
Yeah,
Something that we need to discuss.
we need to look at it, yeah.
right.
Again, let's go, section 17, they talk about safety requirements. And then number one, we don't know they have New York State and OSHA, and maybe that's enough, but then the question there is who inspects for safety? I don't know that Frank really has that training. I don't know that he's ever going, or anybody in that position ever will. So I don't know who's gonna be doing the safety inspections, and I think we need to look at who's gonna be responsible for that. There certainly have been cases, not in our town, fortunately, where things have collapsed and people have been caught in there or even died in there.
I think some towns use third party.
Yeah, I think we should. I mean, you know, even with some of the infrastructure where we talk about compacting around storm drains and that, I think we should. Certainly Legoland did that and had people up there full-time doing the inspections, third party. Under 19, when we talk about B, leak in the service line, I think we have to consider what size leak, and I think you would. If it's a mild leak or something like that, maybe we can afford to sit around while somebody else repairs it. I think there may be times when you're gonna have to do it. The applicant fails to do it within 2 days written notice. I'm not sure, sometimes you can stand around for 2 days. So I'm not sure if you have to put some kind of clause in there or not, but
Yeah.
So much of this up, you don't have any specifications for anything for construction. I'm used to the building code where you can have all kinds of specifications. It tells you what size lumber to use and everything else. This doesn't tell us much of anything like that, what curb box or what we're looking for. I don't know if you need to do that now or you need to do that under a separate item.
Does the existing law give us all of this information?
I thought it gave us more than that, but honestly, water was never my thing. I apologize that I want to say I did.
No, I'm
Not
just
my job,
curious,
man, but it wasn't my job. I'll be honest about that. Okay, under private hydrants, section 24, and these are private hydrants only, these are not the ones along our roads, but I think that you may also have to look at the specs that are required under the New York Fire Code. I think they also, I know they have things in there about hydrants and how far apart they have to be, and things like what height they have to be out of the ground. So I think maybe you have to reference the New York State Fire Code. Under temporary water service, I know that in our water billing for everybody else, we bill them, I think, on a quarterly basis. With temporary service, I'm not sure we can stand back and wait that long.
We don't bill on quarterly basis anymore.
Okay.
Real time, all the meters have been upgraded.
No, but you don't make them pay every.
We bill quarterly.
We bill
You bill quarterly,
quarterly.
okay,
We
that's what
don't
I'm
have
saying.
temporary service.
Okay, but I'm saying temporary service, I'm not so sure you want to wait every 3 months for somebody with a temporary service.
I don't know what temporary service is, we don't offer it now, so.
I don't know, I know that Legoland, they certainly had plugged in and took water from the village on a temporary basis. Basically, I think they had a meter coming off the fire hydrant,
Yeah,
but,
we don't have it in the town, or never had it in the town.
so I think maybe we need to define temporary a little bit more. But I think I'm I'm concerned about somebody essentially stealing water. And the rest of the ratepayers getting stuck with it. I didn't see any definition of, section 26, non-essential facilities. I didn't see any definition of non-essential facilities. I mean, I guess we each have our own definition of essential. For us, it's essential for us to have water for our flowers. I don't think everybody else would see it that way. So I think we just need to define what non-essential facilities are, and then we can deal with it better. On section 29, in D, talks about notification in the newspaper, general circulation. I think obviously it should also be on our website. No reason not to have that there.
I think anything we put in the paper, we update on the website.
We do, I was just gonna say, so.
I think we also have to look at permit fees, and we talk about connection fees. I'm not sure how you, when we did Heritage Estates, when we have a subdivision, we frequently will charge them X amount of money for each connection. So you're gonna come in with 100 units, say it's gonna be rigger. Question is, all right, so he has to pay for X amount of connections based on the number of houses. And then we probably have an engineering firm or somebody out there who's capable of making inspections on the roadway and packing, and then also on the lines, the water lines and sewer lines and all that going in. And they're watching all this, and they get paid by the hour, by the applicant or by the contractor. And then on top of that, we have in the past gone ahead and said they owe us now for additional connection fees. They were getting hit, well, they could get hit, take it back. We could possibly hit rigger twice and not maybe do it intentionally. When we have the developer's agreement or whatever, we charge them X amount because of the house, so we charge them for that. And then we have the connection fee, which is really supposed to be based on the actual cost of us watching it or doing it, and most of the time when we watch it. But then we also charge them can charge a second time because we have the engineer out there anyhow, doing the work, and he's getting paid by the hour. I think we just need to watch what we do and.
I'm confused. So we have a hookup fee that's X dollars.
Right.
Then we have engineering costs to monitor.
Right.
Which is legitimate, comes out of there.
Yeah, no, I agree.
So I'm confused as to where we might go and double.
Because I'd like to go in executive session or do it offline anyhow, please.
I think you can deliver an email to us on what you want. I don't know if I can go to executive session.
I think it can be possible that people get billed more than once for the same work.
Can you define that in the email to us?
Sure, I will do that.
Perfect.
Okay?
Good?
I think so. Under penalties, you have no penalties listed. You can't do this stuff or whatever, but there's no fine of this or a penalty of that. But if you do it every day, we're going to charge you for every day, but we don't have any charges. I don't know if you have to put it in there or we have to do it in some separate thing, but I think you want it there.
We're gonna do it under separate, because if we change the fees, then we're gonna.
And you can do it by resolution as opposed to law. I understand that, and good. Under 36, interpretations. In general, the town board has always avoided being the first person or first group to do interpretations. I don't care if you want to do it, but but otherwise, in general, in most cases, it goes to Frank and his department for code enforcement. But if you want to be the group that always has to do interpretations, God bless you.
I don't think so.
So are you saying the town board by way of the building inspection?
No, I think you just, in Interpretations shall be, I don't know how we do it in other places. It may be that we just make it part of the code enforcement. It's a town code, and it's part of code enforcement issue. I don't want to do that because we always dump on the code enforcement people, I think. But in any case, you have to figure out what, I don't think you want it. Okay?
Understood.
And then lawn sprinkler, we had a conversation about lawn sprinklers before. And one of the concerns I have with lawn sprinklers right now and saying they should be allowed in is the fact that when the planning board, because it was never allowed before, the planning board has approved the latest subdivisions, never accounted for that water usage. So we not, when we said, all right, you're gonna test the wells at this rate, we did not include any water from sprinklers that were not allowed. If we're gonna do that, then we have to go forward and look at it. If you, right now, I think it may be dangerous in that we may have problems with some subdivisions that we approved and didn't take that into account if people start putting them in. And I know at one point in time, Mr. Mumford, actually, because there were issues in his subdivision, actually offered everybody sprinkler systems.
Yeah.
And then we had to tell them, no, you can't.
Right.
Okay, that's it. Thank you very much.
Thanks, Neil, appreciate it.
Thank you, Neil.
Anybody else would like to speak on behalf of this? No? All right. Can I have a motion to close the public, no, motion to extend the public hearing?
So moved.
Second. All in favor?
Aye.
Okay.
Is there a date on that?
Well, we'll have to get with Mr. Ryan.
Yeah. I'm gonna give him the time he needs.
to-
No, I agree, but then I think probably just
And then we'll
renotice it.
circulate it again
Yep.
and schedule it.
Thank you.
Next item on the agenda, the consolidation of two Goshen sewer districts. Sewer District 1, Hamiltonian Park, and Sewer District 2, Arcadia Hills District, into one consolidated sewer district subject to the completion of proceedings pursuant to Article 17A of the General Municipal Law of the State of New York, and further approved and authorized the execution of a joint consolidation agreement. Tracy, the floor is yours. Well, first, does the board have any questions prior to? No?
No.
Oh, the probably went to sleep.
Yeah.
There you go.
Okay.
Yes, tonight, this section, we're talking about the sewer. Can you hear me from here? Can you see behind me?
Yes.
Okay.
Tricia, you might want to get a mic.
You have to record it. That's recorded.
Is this on? Okay. Okay, this section is about the sewer district consolidation that has gone through map plan and report and approval by the town board, and this is to take in any public comment. What is a sewer district consolidation? The town owns the two sewer districts, Hamiltonian Park and Arcadia Hills. Both of those are separate districts currently. They both send wastewater by pump station to the village of Goshen for treatment. Consolidation was recommended in the master plan and report done for the infrastructure in 2022 by Delaware Engineering. And this enables the town to more efficiently handle administration, billing, capital improvements, a larger user base, because it's the same service that each district is being given. You can send your wastewater for treatment and disposal. So yeah, I just mentioned the larger user base. If you have, and we do know that we have a large need for fixing of infiltration and inflow, which is water such as rainwater that gets into the sewers. That is causing an increase in the charges that the village charges the town for treating that amount of water. That's been elevating your rates for quite a while. Let's see, so doing a consolidation can allow you to do more work with a larger user base and either relining or replacing those lines, which is important for you. So what are the new rates for the district? I should note that the rates here, whoops, sorry, on the right side have been instituted in April. The difference being the original, we had two separate districts and they were charged by the amount of water that they used. Each had a minimum fee. Hamiltonian Park was 10,000 gallons and Arcadia Hills was 12, I think. We found during the infrastructure plan that 50% of the people in each district were not using that minimum fee, which means that most lower water users were paying more for their water than were people with larger water uses. So the new components that we're instituting now, that have been instituted, is a straight cost per volume for operation and maintenance based on how much water you use, and a facility fee that's based on the fixed costs within the budget that are used to maintain the wastewater system. So operations, anything that has to do with maintenance of the pump stations or the lines, or people within the district for billing, administration, and things that always are the same no matter how much water is being used. Those are the fixed costs. That is divided out of the budget and divided equally among all users. The other portion that depends on how much water is being used, chemicals and repairs and things like that, under operation and maintenance, that is divided by the amount of water that's used in the previous year's cycle for a cost per gallon, which is translated to a cost per 1,000 gallons, and that's the rate. So the rate that's calculated now is $12.81 per 1,000 gallons. There's also going to be a facility fee instituted for a capital improvement fund, specifically to work on fixing old sewer pipes that are allowing water entry, infiltration and inflow, to either reline or replace according to what the need is. As you go forward to cut down that excess cost you're paying to the village to treat water. So there is a comparison there. In general, you can see the lower users for water users are going to be paying less in the new system for both Arcadia and Hamiltonian Park. The moderate water users are going to be paying about the same for what they did under the old system, but the larger water users are going to be paying more than they did before. And that's more along the lines of equalization of you use more, you pay more. Again, sewer charges, wastewater charges are based on water usage because that's what goes through your house. Sewer is very rarely metered, by the way, if anybody was curious about that. Water use is a lot easier to meter. Okay, so we went through this a little bit, and I forgot to turn your page. Okay, on an annual basis, and I think this is important to pay attention to. Currently, this is based on water usage now, and the fees that come from the village for treating your wastewater. You are currently, as a town district, the average across the state is an annual fee of $656 for wastewater, for sewer, in special districts among towns across the state. That's the average. Even with the new consolidation and lowering the costs to people that are using less water, you're still paying more than necessary. And I really wanted to point out that that really relates a lot to the charges that are being levied for treatment to infiltration and inflow, your excess water coming into your sewer pipes. So it's important to continue with a capital improvement plan and fund and moving forward with that. Okay, so then tonight we're talking, taking public comments. The board will consider a resolution to approve consolidation. The consolidation administratively itself will take effect October 1st. The town did institute these new rates by resolution at the same time as they instituted new water rates. So the rates have taken effect. The actual administration and consolidation is following this process and will take effect October 1st. Updates to the sewer code, and I can see that we're gonna have to have some people have more input on codes as we move forward. And future rates for sewer are gonna be calculated along the lines of the annual budgeting, same as the water, and there'll be public hearings on rate changes along with the budgets every year. So,
Thank you, Tracy.
with that,
Any comments from the board?
Now, I have one question. You know, years ago, this is probably 7, 8, 9 years ago, we rebuilt all of the manholes, waste manholes, and they were leaking water in. Are they still doing okay?
I don't know, we have not done that work. Part of what you're doing for your capital improvement fund will be to do an updated inventory
Right,
and investigation, because, you know, maintenance needs to happen.
Well, we did them first because they were really putting a lot of
That's a key
water in
point,
the
yes.
system.
But you have to maintain.
Oh, I know.
Do these rates include enough of a fund for future repairs and so on and so forth? A reserve fund?
The $30 facility charge was what was looked at within the budget as it currently exists.
Right.
You always have the option on that annual basis
Right.
to look at your new budget, and again, it's important as you budget to make sure that you're budgeting for your regular repairs and maintenance and operation and staff and everything, so you need a consistent, efficient, effective budget, and the rates go on that.
But going into this, was this a relatively comfortable amount that we're charging? And
I
not just
don't have
on the
that in front
charge?
of me, but as accrual with the number of people that you have in those systems, it goes up by a bit. Again, the first thing you would need to do is do an inventory and then decide how much work actually has to be done by pipe footage, by manholes, and you get a cost of that, and then you decide, do you need to up it? Do you need, you know, how much can you get for low interest rates or for loans, or so that it's all part of that budgeting bit. But the first step is to get an inventory.
Right, and you just always are concerned that you're not lowballing anything and then just
Right.
fooling yourself
Right.
by not getting the proper amount, and then when it.
Christine was involved in this.
Christine was involved.
So,
No, I know that.
so
I
I think it's a good start,
Maybe
but again, you need to take a
everyone.
look at what your actual needs are.
I know when Doug and I were on the board, when we first came in, and maybe George later, we inherited operating in the red on some of these accounts, and it was very difficult to assess big amounts just to break even. So if we're
Right.
going to do this now, I just want to make sure that
Mhm.
we, as best we could, accounted for the amount
Right.
of reserve that we'll have, so.
It sounds to me like it's a good start, but again, you need to inventory and see what
Yeah.
your future costs are gonna be and make a decision based on that.
Right.
And you have that option on a regular basis.
Yeah, we will do that, obviously.
Okay.
Thank you.
Yeah.
I'm sorry, too. You're gonna have to open the public hearing for this.
Did you do it? Can I have a motion to open the public hearing?
And now we'll
So
open the
moved.
public hearing.
Second.
I didn't open to the public
It's
yet.
okay, we got the presentation.
Yeah.
It's
The
okay,
explanation.
we're not late.
No, we're good.
Aye. Second. All in favor? Aye.
Aye.
At first, I'd like to open it up to anybody that lives in Hamiltonian Park or
Okay.
Arcadia Hills.
Yeah.
They'd like to speak. Okay, just open it to the general public now. Anybody would like to speak on behalf for or against? Neil?
I'm not against anything, I'm just, my question really is, when you talk about inventory, I would assume that we have an inventory already of how many miles of pipe or how many.
No, I mean inspection for current status, inventory, how much is that, the whole shebang.
So we're
Yeah.
talking about condition also, which will give us
Yes.
some idea about what we have to do planning forward.
Yeah,
And we have so
has
many
anybody
pipes-
looked at this in the last year? What about this manhole? Yeah.
So,
that
I
kind.
agree, and I think we really do need to get that. The other thing is, you talk about I&I, and I'm not sure most of us understand I&I, particularly in terms of what we as homeowners can do.
That's a good point, and that would be part of inspection too. You can do smoke testing if you need to for leaks and for, inflow is that connection, maybe illicit connection into the sewer pipe from roof leaders when it rains, the rain that falls off your roof, often there's a pipe that comes down and drains that into your lawn. Some of those are illegally connected into
To
sewer.
the sewer, yeah, we've inspected and caught some now as well.
Right, right.
yeah.
So that's a big part of that excess flow that you're paying for at the wastewater treatment plant in the village. Infiltration is that stuff as the groundwater raises, as rainwater flows across the land and gets into pipes that are broken or joints that are not connected. So both of those are I&I. So there's two ways to look at that homeowners understand what those connections should not be. And then the other portion is just finding those, prioritizing which sections of pipe are the worst, maybe the oldest, maybe not, because ground heaves and freezes and frosts in different ways, and pipes can be affected by different materials and different pH of soil, et cetera, and so forth. Cameraing, smoke testing, all of that is what I'm talking about for inspection of the underground and inspection of the above ground
Well,
too.
we have an inventory of all the things we've done. For example, we rebuilt all of the manholes, but that was several years ago. But how many miles of relining the inside of the light?
Well, and it's good to start with knowing what you've already done and listing it and starting from there. But in order to get the best bang for your buck, you want to prioritize which is the worst sections of pipe that are letting more water in, and do those first.
Yeah, we have cambered the system already, we have copies of that.
Yeah, we did that and we also smoked
And we
it.
smoked it, yep.
Yeah.
A lot of people.
So you already know some of those sections.
Oh, yeah.
Yeah.
We're diligent about doing
Yep.
that.
Now, just one more comment. I know one of the big problems with the smoke testing is that people get really bent out of shape when it's their house and the smoke's coming up in their house.
Yes.
I think, oh, well.
Yes, I've done it, and the fire trucks have shown up.
Yes.
And it's important to notify people. Problem is, not everybody gets the notice.
Good. Thank you.
Yeah.
Yeah, and I'm sorry, I couldn't read that. Do we have an idea or an estimate dollar-wise what we think we're overpaying?
What, to the village and sewer? We
Yeah.
don't.
We have no idea.
We know, we're working on our ability to reline all of the sewer lines in Hamilton Park and Arcadia Hills. We're working on a price and trying to go out and get grant money now from the federal government. We just missed the, Senator Ryan had something and we just missed it, so we're hoping to come back on the next round. We're working on that.
Can you give us your name, sir, and your...
My apologies, Steve Betancourt, Goshen, New York.
There you go. Thank you.
Sue?
To answer his question,
Sure.
because I've done not a lot of stuff.
Sue, you gotta come up,
Oh, yes.
please. It's for the cameras. There are people out, there's quite a few people out there looking at the cameras.
Sorry. I know that there's a flow meter for how much sewage goes in. I believe, I don't know where it is in Hamilton Park, to be honest with you.
Right.
But the village knows, and when it rains, if you
Oh,
look
we know
at
that
the
it goes
chart.
up, there's no doubt about that.
Yes,
Yes, we do know that.
you know, I mean, the pipes are old, and same with Arcadia, but you can figure out exactly, if you look at the charts, what the average should be, and when it rains, how much it goes up, how much more you're paying
yeah.
to treat,
Correct.
how many more gallons. So
You're
you
absolutely
can
correct.
get-
We do.
I stand corrected, you're absolutely
You
correct.
can get a rough idea of what it is. Anyway,
Yes.
so I just wanted to point that out.
No, you're
It's
absolutely
not-
right,
No.
absolutely right.
Budget
But not to the point where I could charge an individual resident.
No.
The budget officer knows too, because we know how much we bill
Mhm. And we
from
know
your
how much we
meters,
pay.
and then we know how much we pay the village.
Right.
So the difference is what we're
I
losing.
know.
It's substantial, I remember looking at
Yeah,
it
it's
for the
substantial.
infrastructure plan, yeah.
Yeah.
Anybody else?
I was gonna say, I think it used to go up 2 or 3 times what the normal flow is,
Yeah.
at least, in Ham Park. Like if we go produce,
On a major storm, if we would've got the 6 inches the other night, it would've been pretty high.
yes, it would.
Anybody else? Do I have a motion to close the public hearing?
So moved.
Second? Second. All in favor?
Aye.
I need a motion to approve the resolution approving the consolidation of 2 town of Goshen sewer districts to wit, Sewer District Number 1, Hamiltonian Park Sewer District, and Sewer District Number 2, Arcadia Hill Sewer District, into one consolidated sewer district, subject to the completion of the proceedings pursuant to Article 17A of the General Municipal Law of the State of New York. Have a motion?
So moved.
Need a roll call?
Yeah.
Second.
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 Roll call.
Councilmember Cantorino?
Aye.
Councilmember George Lyons?
Aye.
Councilmember Florio?
Aye.
Councilmember Bloomfield?
Aye.
Supervisor Bencher?
Aye.
Do you have a pen, Joe?
Yeah.
Get a copy, you get a copy?
All right. Good.
What's up? Can we get back to vacation?
Item number 1, introductory law number 10 of 2024, Chapter 80 modifications. Some discussion on this introductory law. It's, just so everybody knows, it only affects IWS right now. It's adding the exception of existing facilities and acreage from 300 to 430, Altori 121, Transfer Station 16, Orange County, Landfill 208, with the expansion of 75 acres. So we have changes in our local law that would disallow IWS to operate in its current location. So the town board, the planning board attorney drafted this?
Yes, Kelly drafted that.
Kelly drafted it. You have it in there? Any questions, concerns?
So it says here that the proposed facility to be modified shall adjoin the right-of-way of an existing state highway or county road. Is that Hartley Road? Are they saying that Hartley Road?
No, what
Is
they're
the
saying
right-of-way?
is our new law
Right.
requires it to be on a county highway or a county road or a state highway.
Right.
Hartley Road is a town road, so they need an exemption. That's what this local law is,
Right.
exempting them from, as an existing user to the law.
Right, that's how I read it.
Yep.
Because they're not, so at this particular point, they need the exemption in order to continue to operate. Is that correct?
Correct.
Okay. So along with this, there was going to be an agreement of some sort of fee per tonnage that they were going to pay us.
Correct.
I have not seen that agreement, nor do I know the specific amounts of what was agreed upon, or that they had offered. I know we can't charge a host fee, I understand that, so I'm not gonna,
So there are two things that we negotiated, that Kelly is putting together an agreement that would be signed prior to the planning board giving them their final approvals. They're going to be paying us $1 per ton moving forward,
right?
and they're going to be paying us $200,000 in the rears for everything they didn't pay in the last 12 years.
Right.
That would be part of the agreement that would be signed prior to the planning board approval of that project.
Okay, I just wanted to make sure
Yep.
now, because we're approving something,
Correct.
and I'm of the opinion that I don't want to approve anything until that agreement is signed and part of
We can,
everything we do, so.
you can check with Kelly tomorrow, but I think that this is a requirement for the planning board to move forward on what they're doing. That's why she wanted the ADB changed to include them, but we can check with her tomorrow.
Yeah, I mean, I.
She drafted
Frankly,
the
I don't
agreement,
move
so.
forward until I see that agreement.
Oh, the new agreement?
Yeah, and-
She's drafting that.
And have it signed, and she's been drafting it for a while, so, only because I wanna make sure it's bulletproof and the town is not liable once we pass the law. We've been this route once before, so.
All right, so all we're really doing tonight is assuming the agency and moving forward, not approving anything.
Yeah.
But I agree with you, but that's what we negotiated with IWS.
So $1 per.
$1 per ton, so that would be roughly under the new amount that they're producing now, that is roughly, I think it's $120,000 a year. And then the $200,000 is for goodwill for anything that they hadn't paid in the past.
So based on the permit, how much are they taking in now and how much are they gonna be able to take in?
I think it's
it's only double,
640 tons a day under the new 360 approval. That's what they've been taking.
That's it all? So-
Since 2013, their 360 was updated.
So we're not increasing any amount that they're taking?
As of right now, no. That's what they're currently taking in on their 360. It doesn't match our ADB agreement. That's
No,
what
I know
they're.
that, I know it doesn't, but I just wanna make sure that there are no new facilities and no additional facilities.
Nope, it's an
Okay,
existing facility.
okay.
They're modernized, from my understanding, and planning board, Neil maybe could talk about it, but they're modernizing the building and updating it to current code.
Okay. And this is strictly transfer waste?
Strictly
Comes
transfer,
in and leaves?
strictly transfer station,
Okay,
an existing
I just
transfer
want to
station.
confirm that and go on record to make sure that we're not increasing or doing anything new or additional to what
Correct.
we have there. Okay. We're good.
So it's hard for me to compute what is fair and equitable, I guess. But as Phil said, and I said the same thing, there was supposed to be an agreement, and for whatever reason, I guess we're as guilty as the other people. There was no agreement, no money coming forth. But what you just said was 120,000 per year,
We can go forward, correct?
right? 120,000 a year, and we're getting 200,000 for 12 years of no payment?
Right, they're supposed to pay a nickel a ton.
Right. So I don't want to, what I'm really saying is I don't want to leave any money on the table. Should we be asking for more?
That is more. If you calculate their tonnage at 5 cents, it'd only be somewhere around $35,000 they would have paid us.
So basically what you're saying then, I guess this is.
A lot of goodwill there.
This is essentially what is going to happen. There can't be any more, so to speak. As I said, I don't want to leave any money on the table. Let's say they give us 300,000 in arrears.
Well, that's what I negotiated with them based on the fact that they only owed us $35,000. We got 5 times what they would have paid at a nickel a ton.
Okay.
But they're gonna do that in 1 year, correct?
It's gonna be up front, yeah.
Yeah.
Right.
And then the only other thing is I'm 100% right behind Phil. This is going to be a local law.
Yeah.
Just be an amendment to the local law.
So there's going to be a public hearing,
Correct.
right, and all that stuff.
Yeah, right
So
now we're just going through secret.
when this goes through the public hearing,
Mhm.
and then we get to the point where we're going to pass it, that same night, there has to be this agreement of the $1
$1 and
$1
$1
ton
Right.
for each year going forth, and the $200,000 in the
We-
legal document that Kelly is producing.
We would
I
have had
don't want to pass this unless that is also passed at the
You
same
will
time.
probably have it prior to that.
Oh.
It's just Kelly getting the
That's
document
all.
together. Kelly's getting the document together, it's just taking her a little while, but they're ready to sign that portion of the agreement.
That's even
That's
better.
agreed upon.
I'd rather do it before.
Oh, yeah, yeah, and I'm really concerned that it's a bulletproof agreement based on New York State's approach toward host fees. I want to make sure it's not a host fee. That's number one. Now, there wasn't, I will, just for public information, I think the last time we discussed this, someone talked about the amount of taxes they pay. And I think they said they paid like 43,000 in taxes a year. And they pay actually 56,000, which I think based on the income method of appraisal was really, really low. But our assessor said
We don't do that.
that we cannot do anything. We can't increase the tax, we can't do anything because it's discriminatory. Because I said, someone has to go right back out there and appraise this thing. And he said we couldn't do it now, but maybe our town attorney would look into that and see if there is a way where we can do a fair assessment of the actual taxes that are paid.
Well, they're expanding the building, so there'll be a reassessment of the building.
Well, I want to make sure the reassessment includes a valid reassessment of the whole plan and not just, just that little portion that we're.
As you're aware, we assess based on property value, the value of the property, not on how much money
Well,
it's
it's a business, so there could be three methods of assessment. Assessment, appraisal, and property's appraised a little more than the assessment should coincide with the appraised value plus the.
Yeah.
So all I'm saying is, we should take a look at it. We want to do everything legal, but we want to make sure that everyone is paying their fair share of taxes. Because they do use the roads, and we pay for the roads, we pay for Hartley Road and all of that stuff, so
Agreed.
they need to pay their fair share. You mind doing that? Thank you.
Yeah.
That's perfect. Okay.
Rick, anything?
Good.
Doug, anything? We're all good?
Do we have to set a date for a public hearing?
Well, we gotta go through the process here. So, I need a motion
Get
to,
the sheet up enough?
I need a motion to assume lead agency and type this action as a type 1 action.
So moved.
Second.
Sorry,
Yeah.
many people talk at one time.
Phil said so moved.
Yeah.
I second it.
Okay, Phil and Doug?
Yeah. You need roll call?
No. I don't need a
Oh, we're all
All
in
in
favor?
favor?
Aye.
Okay.
Okay, need a motion to issue a negative declaration.
So moved?
Second. All in favor?
Aye.
Aye.
All right. I need a motion to schedule a public hearing for introductory law number 10 of 2024 entitled Chapter 80B modifications. It'll be on Thursday, August 22nd at 7 p.m.
Do you want more time? You want me
Yeah.
to push it
Yeah,
out a week? 'Cause
I'd like for Kelly to make sure she has the
Is that
document
very
ready.
soon?
So could we go to first meeting in September at least?
Yeah. Do you know the date you have in calendar?
Fifth.
September
I
5th?
think it's the 5th right now,
It's the second Thursday.
Second Thursday.
right? The 5th is
12th.
Well,
planning board, right?
September 12th.
Okay, very good.
Did I get the, I made the motion on that. And, George?
I'll make the motion.
And a second?
Second,
Second.
all in favor?
Aye.
Next item on the agenda is to review and adopt introductory law number 4 of 2024, utility poles. We've got incorporated comments from Orange and Rockland, and they were reviewed by Attorney Norton. One minor change that they did change to the text. Motion to, one minor change that did not change to the text.
It didn't change the text.
Oh.
There was a minor change that didn't change
I got
the
you.
text. But now it's gonna be local law number 8 because we didn't pass the water.
So we already looked at this and reviewed it, right?
Yeah,
We did.
And we said we
We
were
had a
gonna wait
public
for
hearing
Orange and
and-
Rockland to get
yeah.
changed. Okay, so they made the changes.
They wanted to change, look at it.
So are we at the point now where we want to accept this?
Yeah.
Yeah, they made their changes to,
We actually accepted it in 2023, but when I mailed it, it got to them in 2024, so they wouldn't take it.
Right.
And then I had the wrong chapter number, I had it as chapter 108, when I was supposed to be
And
the
then-
number. So
and then we found out from Eric that they
Yeah,
wanted to add
Eric
some
wanted
stuff.
to look at
The
it.
major problem with the original local law was unbeware to us. We thought that Orange and Rockland owned every tower, and they don't.
Yeah.
Verizon owns some,
Right.
utility, the cable company owns some, so they wanted some, additional information added to it saying that the owner of the pole is responsible for
Right.
removal, not Orange and Rockland.
So how do you need that motion?
By roll call,
So-
somebody can make the motion.
Yep, I will do it now.
It's gonna be local law.
Local law number 9, right?
It's gonna be 8
Eight.
now.
Change that.
So I make a motion that we adopt local.
Local law number 8, titled utility poles.
Titled utility poles.
Second,
I'll second the motion.
all in favor?
Aye.
A roll call, you need?
Yeah, Councilmember Bloomfield,
Aye.
Councilmember Florio,
Aye.
Councilmember Lyons,
Aye.
Councilmember Cantorino,
Aye.
Supervisor Petra.
Aye. Okay, as you're all aware of the green sand system that we've been working on and we approved to move forward, it went out to bid this past week, and the document from Delaware is in there. Dear Supervisor Betro, bids were received on August 7th for Contract 1 and Contract 2 of Hamiltonian Park Water Treatment Improvements. Only one bid was received for Contract 1, General Construction, and 2 bids were received for Contract 2, Electrical Work. The bid tabulation is attached to the letter. The low bidder for both contracts was TAM Enterprises. We have reviewed the bids and confirmed that TAM responsive qualified bidder. We recommend that Contract 1 be awarded to TAM Enterprises for $1,311,639, which includes the reduction when using this bid altercations of a pre-engineered structure. We also recommend that Contract 2 be awarded to TAM Enterprises for $356,086. Any questions?
Yeah, I got that, I guess, on my phone today. So let me just go back, see if I can read where it was.
Did you see the,
I didn't, I
They were
actually.
the only bidder.
Oh, no, I know that. No,
On the one
no,
portion.
I don't have a major problem with it. All I was trying to get, wrap myself around was, okay, the bid for the actual stuff was $1,380,000. Then there was a alternate bid of minus $468,000.
Right.
And that's because the building is already there? Is that what?
no, that's because the original bid was for a prefab, the original was for a stick-built building, and TAM Enterprises bid on a prefab building
Right.
to put in there.
So then it goes down to $1,311,000?
Correct.
And that's, they're doing a prefab
Correct.
building?
Carolina Carport.
That right? And then the other part was the electric, which is, they were the lowest, 356.
There's also $100,000 contingency built into there that may or may not be used for any things that may come up during the contract.
Right.
Got it.
And I think you got 2 bids on the electrical.
Yep, the electrical was $481
Yeah.
and $356. They were first by $130,000.
Right.
Joe, do we have any idea when this will be finished and started?
Hopefully starting in the next 2 weeks.
Oh,
Wow.
okay.
My understanding that the equipment, Delaware said the equipment is going to take about 90 days to get here, but there's a lot of work that has to be done, tying the wells together with pipelines, putting the building up, getting everything ready to go. I did ask Christine to go out and run a calculation. So I asked her to run a calculation at 1.4 million because we have $200,000 from Senator Skoufis in this. We start looking for additional grants on it. And on a 30-year note for 1.4 million, it's going to cost $154 per home per year. On a 20-year note, it'll be $186 per home a year. Which I think most people spend more on water filtration systems there than the $144 a year.
That'll net them less. Right.
Yep. All right, any other questions? No? So I have a motion to award the Hamiltonian Park Treatment Improvement to the lowest bidder received by TAM Enterprises in the amount of $1,311,639 for contract number 1 and $356,000 ODE6 for contract number 2 as recommended by Delaware Engineering.
So moved.
And I'm
Second.
sorry, then we have the supervisor authorized to sign the contract.
And the supervisor.
And the supervisor authorized to sign the contract. Okay.
I'll second the motion.
Oh, you need a roll call?
Yeah.
Yeah.
Big one.
Councilman Blanchard,
Aye.
Councilmember Florio,
Abstain.
Councilmember Lyons,
Aye.
Councilmember Cantorino,
Aye.
Supervisor Petra.
Aye. Next item on the agenda is
4.
Lot 4, yes. Approve and authorize the supervisor to sign the indemnification hold harmless agreement and easement for the pump station along River Road. This is a agreement with Dasney, I believe,
Yes.
for the pump station that they're going to be installing for the new line, their new sewer line that's gonna be going to Middletown.
So that's the forensic center
Yeah.
is gonna be pumping the sewer to,
At some point, they'll be pumping the sewer to Middletown when the new line is installed, correct? Their new line.
yeah.
Yeah.
Right, any problems with the whole harmless?
No, it was drafted by Kelly, I reviewed it, spoke with her, and I'm comfortable with you moving forward, for sure.
Anybody have any questions?
I don't.
All right, so can I have
So moved.
second?
To approve the authorized supervisor to sign the indemnification agreement. Second, okay.
What Phil said?
A roll call,
Roll call?
please.
Yes.
Councilmember Cantorino.
Aye.
Councilmember Lyons.
Aye.
Councilmember Florio. Councilmember Bluefield.
Aye.
Supervisor Bencher.
Next item on the agenda is review and approve the extension of the special permit for SR 94 Light Star. With a letter from them. I read on behalf of the above applicant in response to the correspondence received from Sean Hoffman, PE, on July 22nd. We understand that the town board and planning board are required to act on the application, grant, deny, or grant with conditions within 62 days of the closing of the public hearing, which may expire on or about August 7th. Applicant hereby consents to a 60-day extension so that the response to the comment letters be finalized and submitted. The applicant will cooperate with the town if any additional extensions become necessary. In addition, the applicant respectfully requests a virtual workshop meeting to discuss the drafted response at a high level and to ensure that the documents will be provided are sufficient to address all the concerns and requests. Is that meeting with us or with the planning board? With the planning board, okay.
They just want the extension, right?
Yeah.
All right, any questions on it?
No.
Okay, so can I have a motion to extend the permit for SR 94 Light Star to October 10th?
So moved.
Second?
Second?
All in favor?
Aye.
Okay, we have a letter from Kelly Norton and the planning board. So the next item on the agenda is to review and approve the appointment of Robert Miller as a hydrologist consultant for the planning board. Kelly writes, due to the passing of Bill Canavan, the planning board has been looking for a new hydrologist to assist on application reviews. During the executive session in last night's planning board, the board met with Robert Miller, recommended by Sean Hoffman and Delaware Engineering. They have requested that I reach out to the town board and ask that the board approve him as the planning board's hydrologist at your meeting on August 8th. I have attached his very lengthy and impressive resume as well as his fee schedule.
Yep.
So, I move that we approve the appointment of Robert Miller as hydrologist consultant for the planning board.
A second?
Second.
All in favor?
Aye.
Okay, next item is the new fee schedule. Review and discuss the new fee schedule for the town of Goshen. Mary went to town.
I did not.
Yeah, you did. Yeah, you did.
Look at those colors.
I only had one question. That was about the roof. Why are we charging a fee for people to put on a new roof?
Inspection fees, they gotta go out, code enforcement's gotta go out and inspect it.
I know.
You could ask Neil.
So the guy's gonna say, okay, so I'm putting on a new roof, you don't wanna inspect it, but you wanna inspect my hot tub?
Yeah, yeah. That's all I had to say, that's it.
Listen,
I'll approve the 10,000 things here.
yeah, listen, I understand, but,
Okay.
all right, any other concerns other than Phil's?
Need a motion to accept?
Yes, I need a motion to accept.
I'm not gonna do it.
New fee schedule.
I'll make the motion.
Second, all in favor?
Aye.
Okay.
Wagon wheel.
Next item on the agenda is review and discuss the approval for the festival permit for Wagon Wheel Farm on October 3rd, 5th through the 6th, 12th through the 14th, 2024. I think this is something that they've had in the past, correct?
Yep,
Yeah.
essentially, the same request, just updated for this year.
Right, but we're gonna get insurance coverage for this event. I wanna make sure what, if we prove it, that they supply the insurance coverage.
Yeah, they gotta go through the code enforcement process, they wrote a
Right.
letter to Frank here.
Right.
Yeah,
Doing a site plan, doing a noise plan, doing security, bathrooms are gonna be there.
Right. Does it say anything about insurance on there?
I'm reading the letter as quick as I can.
Yeah,
There
okay.
was- there's a
Well,
whole
yeah, well,
process.
I can say the last 2 years at least that I've been doing this, they had to submit that.
They've submitted.
Started with this,
Right,
but
right.
I don't know if it's listed in that.
It's hold harmless agreement.
That's right.
Yeah, no, I,
Yeah. There's a hold harmless agreement, so he'll give me the insurance.
There you go.
it's,
All right,
yeah,
so
it's
they have a
attached.
temporary liquor license, so they're gonna be required by New York State for liquor liability insurance and workers' comp and disability insurance to get their permit.
Right, I just want to make sure we're covered for any liability.
So we just make sure that we're added as additional insured?
There you go.
Yeah,
Okay.
it will come to, it should come to Frank and then by way of that back to me.
Right, they just,
So we just
note
review
of
it
it
to
so
make
we
sure
don't
that-
forget it, that's
No
all.
doubt, no doubt.
Okay, next item on the agenda is
I need a
reviewing.
motion to approve.
Oh, I'm sorry.
So moved.
Second,
Second.
all in favor?
Aye.
Next item on the agenda is review and approve the July 25th, 2024 town board meeting minutes. Any questions?
Nope.
So can I have a motion to approve those minutes?
So moved.
Second.
Oh, wait a second, I was absent, so I'm gonna
I
abstain.
was at it as well.
Make the motion.
Oh, yeah. Right.
Bill,
I'll second it.
You can make the motion.
All in favor?
just can't vote on it.
Right, aye.
Too late.
He's good.
so you learned something new, right? All right, the chief has we have an application here from a part-time police officer, John Barton Jr., at a rate of $33.65 an hour. Comes, went to the Rockland County Police Academy. An interview was done, it's in here.
Yep.
He, according to the chief, passed with flying colors. He's also, my understanding, he's also been EMT trained.
Good.
Cool. Okay, need a motion?
I need a motion to approve the hiring, yes.
So moved.
Second,
Second.
all in favor?
Aye.
All right, just some information. Myself and Christine sit on a very extensive call with Standard & Poor's.
Wow.
We went through the town where we are today, and I'm happy to say that the rating that we had, that Doug was instrumental in getting us, has stayed the same. We are AA+ rating, only town in Orange County has a AA+ rating.
We want to keep it that way.
We're as tight as the bark on a tree.
All right, next item on the agenda is review and approve the motion to authorize supervisor to pay accounts payable check run August 8, 2024 in the amount of $156,793.62. Can I have a motion?
So moved.
Second,
Second.
Got George and Doug.
all in favor?
Aye.
Got two informational things from the budget officer. There's an AP review for July 2024 submitted by the budget officer, and also an AP for July 8 submitted by the budget officer. They're attached. Anybody have any questions on them? All right. Privilege of the floor. Open for any resident that would like to speak.
So moved. Oh, we don't. Okay.
Chris Healy, Town of Goshen, thank you. Sincere condolences to the Florio family. It's a tough time, I've been there. Rory, you didn't even go off the bench tonight, bro.
I gave you the look.
We haven't heard from you, nothing.
This is,
Like you're suited up, but come on.
I'm ready to go.
No, I thought they pitched to you eventually,
I'm
but
ready
okay,
to
you're
go.
ready to go, that's what matters,
In case you
appreciate
call
that.
my number, I'm ready.
The IWS deal, if I'm not mistaken, there was a deal in place some years ago. They just never did anything with it. I truly hope that you make them bring in a bag of cash, and Phil, I hope you're there to make them count it out on the desk. Excellent.
Count every penny.
I can say, I'm on Gate Schoolhouse up to 17M 3-4 times a day. I live right around the corner. There's been a massive uptick in IWS traffic over the last 10 years. Are they currently using all 430 acres? I don't know that I need an answer to that, but what I'm saying is,
They don't have 130 acres.
well,
Yeah.
we're increasing from 300 to 430 acres.
Because we're taking into account all the solid waste facilities.
Understood.
Yeah.
So they're not increasing their footprint, updating whatever it is that they're doing, they are using more and more town resources, that is the roads, etc. Thank you all for making sure that they're paying their fair share. Get that cash up front. Thanks to Neil Halloran tonight, he gave a tremendous amount of information that I think the board really took in. I certainly took it in. The man has a wealth of information here on his own time. I really do appreciate all that he has to say. I think that the report that Delaware Engineering, the new law, is it's terrible. It's full of holes, and it's weak. It's about the weakest piece of paperwork I've ever seen. It really does need to go back to the drawing board. It is rife with mistakes and far too much to be interpreted, and that's just not how code works. Finally, the Delaware Engineering Report on the new water district. Last we spoke, Supervisor Petro, you were sending it back to them for a revision. Do we have an update on that?
Still working through the pricing right now. It's just coming back way too high. So they're making modifications to it. We should have it soon. That's all I can tell you. You'll be the first person that gets it, I promise you.
I appreciate you keeping on it. Thank you very much.
I'll CC you on it while I CC them on it. So you can
Maybe
see
not
it.
as much as necessary.
But no, we need to get the number because we need to go out and get, we need to go out and get grants on it.
Of
So
course.
we are diligently working with them.
Good to see the full board back tonight. I'm glad everybody's healthy. Good to see you all, and for the hard work tonight. It's been a long night. Thank you all very much.
Mark Smith, Goshen, my condolences. A couple of months ago, I was here and I was asking you about 17M, and how dirty it was. It was about a week later I was out there. I don't know how it happened, but it's all cleaned up.
Yes.
I don't know if anybody's noticed, but if you go out to the dump, I go out there twice a week, because the sides of the roads are clean.
I know that Assemblyman Marr had a lot of young Republicans out with him running the streets. There's like 30 of them out there picking up garbage along 17M and going to Chester and on its way to Middletown.
I hope he keeps it up, because it's market difference.
I also do have to say that the Sheriff, Paul Arteta, has instituted road crews again. So we've had multiple road crews out there.
Is that with his
of
clients?
inmates. What's that?
Is that with his clients?
Clients?
Yes.
My client as well.
Yeah, so no, listen, I think
I'm glad we
that,
get use.
no, I think that really is good. I mean,
Yeah.
he's putting them to work. So he's out there in all the local municipalities, and they're out there picking up garbage.
Right, good.
Yep.
Rory, do I have an answer this week?
Nope. See, Chris, you got one shot at it.
Yeah, what's it? You blew it. Yeah, this was the moment.
I'll talk to you offline. Where we're at, all right?
Okay, that's all, thank you.
Boy, Rory.
Anybody else like to speak? Neil?
Thank you. Just first a question. I'm not sure all of us understand what Zasney is or River Road is. So somebody could just kind of explain that for us, because.
River Road is Amy's Kitchen Road. Dasney is the development dormitory authority of the state of New York.
But essentially, they're kind of the finance arm of a lot
Right,
of
they
grants.
they own the property for the psych centers.
Correct.
Right,
Yeah.
but I'm not sure most of us know that. Good, thank you. The real reason I came here tonight was, I had two things that I sent, I believe you received. One was I had a letter I sent out to DEC regarding the Altori landfill. Obviously, I got the slow response of 0. And so the question is, how much further you want me to push this? And I have no problem trying to foil for everything I asked for, or going up there and even meeting with them. So I know in the past I went up there and foiled stuff, and it cost $100 more when we were doing a tax cert on the Altori landfill. If you want me to go forward with it, I have no problem doing that with the ERB, on behalf of the ERB.
I mean, it's an environmental issue, you're the head of the environmental review board, and I think that you don't need our permission to
Well, I think about,
investigate a review.
okay, no, I have no problem with that, I just want
Based
to.
on your letter, it's gonna take them a year and a half to get answers from you.
We'll see, we'll see, but I think we need to get there.
No,
And
that's
the second
fine.
thing is, Ms. Holly O'Hearn sent a letter to the ERB, and I think to you also, and she had a number of questions regarding the Tilcon quarry. For those people who don't know in the audience, Tilcon is now taking stone out below sea level, and I think they're applying to go even further. So anyhow, she had a lot of concerns. I plan on addressing the letter at the ERB meeting next week. The question is, how far does this board want me to go beyond that? I have no problem, again, going to the DEC about it, but I don't want to go to outside agencies without this board knowing it.
Again, it's an environmental
Sure.
review issue.
Yeah.
You have full authority.
Absolutely.
Okay? All right, thank you very much.
Thank you.
Anybody else? All right, got two announcements.
Just a quick one, changing our prayer. Mary,
Yeah.
do you think we can get the agenda out the day before the meeting?
I'm at their mercy, Jane.
My fault. We had two things that were iffy getting added to tonight. So that's why you got it late today. I'll do my best not to.
Excuse me, it wasn't late, it was 1 o'clock.
Okay. I'll do my best to have it done by Tuesday afternoon.
That would be great.
I mean, you can always add to it.
It'll change.
Okay,
If I
I'll
put it out on
tell
Tuesday,
you,
it's gonna change.
here's what I will guarantee you. I will do my best to get it done by Tuesday afternoon, but I can't be held accountable if I add something that isn't on. So I don't want anybody coming here and say, you're trying to sneak something through. So sometimes things do come up on Wednesday and Thursday that we want to address and get on it, like this TAM bid. So it didn't get awarded until sometime this morning, but I wanted to get it on because I wanted to get the work started. So as long as we could agree in principle that I'm be able to add things and not be accused of
Well,
trying to hide
that's on the
something.
site, it says it on the site.
Yeah. I will do my best.
It's not gonna be Tuesday.
No, I said I would do my best.
I think we need to define what best
I
is.
said I would do my best to complete it by Tuesday
Yeah.
at 5 o'clock.
Predominantly is best, right?
I will do my best to complete it by 5 o'clock on Tuesday and deliver it to Mary.
And you'll get it
Wednesday.
Thursday morning.
At 1:30.
I have another question. It's very nice that we speak at the end of this meeting. Would we be able to speak at the end of the planning meeting?
That's not up to us.
That's not.
I don't know if they, you know,
Generally speaking, generally speaking, there's no public comment at planning board or ZBA.
unless it's a public
Or
hearing.
any-
Or unless it's, yeah, or ERB, unless it's scheduled that way.
If they schedule a public hearing.
But if we have questions, they'll answer our email.
I can only speak to the role I have here in ZBA. ZBA, if there's not, like, there's communication, sure, I would entertain addressing it the best I can, as long as it doesn't violate no.
So why don't you
meeting
send me an email request?
Yeah.
Send me a request on what you're looking for,
Yeah.
and I'll have a discussion with Lee Burris
Okay.
and see how we could accommodate you.
Okay, thank you.
That's it?
Got two announcements?
Two announcements from
Two.
Two announcements. My first announcement is National Night Out was canceled, and it's rescheduled for August 15th at the park, Myron Adamski Park, 6 to 9 p.m. And tomorrow, the farmer's market is canceled due to the weather.
I have a motion to close the August 8th, 2024 town board meeting.
So moved.
Second? Second. All in favor?
Aye.
Thank you, everybody.
Okay.